We had several hearings on the custody case, and this incident occurred 9 days prior to the day that we were set to have our trial in juvenile court. I believe that he had every intention of killing me that day. It was the most terrifying experience of my life. I think about it every day. It has changed the way I think and the sense of safety I once had. It is impossible to fully explain what it feels like to know that you came within inches of losing your life at the hands of someone you had known for so long and once trusted. The shot that hit me in the leg was very painful. It was difficult to walk, and I couldn't bend my knee for several weeks. My vehicle was destroyed. It took 3 months for me to replace it, and during that time I had to figure out how to get to and from work and anywhere else I needed to go. This trauma has not only affected me, but my entire family. It has caused a tremendous amount of fear, stress, and emotional strain. We are trying to rebuild a sense of normalcy. Noah's actions that day put my life and the life of several others in serious danger. This will have long-lasting effect on everyone that was involved. I respectfully ask the court to impose a sentence that reflects the seriousness of the crime, recognize the damage that he has caused, and protects the community from future harm. Thank you.
Thank you.
Your Honor, Ms. Noble was not able to come today because she indicated that it created too much anxiety for her to be here and to address the court and to kind of go through this situation again. But she did state to our office that she believed that you would do the right thing. So I think what I want to address right out of the gate is the absurdity of some of the statements in the letter that the defendant submitted to you. In the letter, the defendant stated, and I quote, "I have no recollection of these things and would never do them in my right mind, no matter how angry or mad I was at someone. I am far from a violent person, even when angry." End quote. Think about that for a second. He wants you to believe that despite all of the planning and preparation that went into that day, he can't remember any of it because he was not in his, quote, right mind. Your Honor, the facts of that day demonstrate that that statement is a complete and total lie. This is someone who got up that morning and called off work so that he could specifically carry out this shooting. He then put on all black clothing and loaded his assault rifle into his car in a way that he would not be detected by the camera at the front of the house. He then drove over 50 miles from his residence in Piqua to Wayne Township to carry out this shooting. This shows the distance and time that he traveled to come all the way here to carry out this violent attack. When he arrived in Wayne Township, he concealed himself down a long lane and hid in a tree line for over 20 minutes while he waited for Emily Bear to pass through that intersection. And the reason that he knew Emily would be traveling through that specific intersection is because he had looked at the Life 360 app on his daughter's phone in the days leading up to this shooting, which showed that Emily went home every day during her lunch hour. Once Emily entered the intersection, he fired multiple rounds from his rifle, repeatedly striking her vehicle. Look at that firearm, Your Honor. Look at the ammunition that he was using. And now look at the location of the bullets on Emily Bear's vehicle. All over the doorway. Your Honor, these were all intended headshots. He was not intending to injure Emily Bear on that day. Rather, he was intending to kill her. After striking and injuring Ms. Bear, the defendant continued firing and struck the vehicle directly behind Ms. Bear, which was driven by Ms. Noble, causing her injury as well. To this day, she still has a bullet in her body. Additionally, we know that one of the bullets struck Mr. Piper's house across the street, putting the occupants of that home in danger as well. The defendant then drove all the way back to Piqua, dropped off the firearm back in his bedroom, again without being detected by the camera at the front of the house, changed his clothes, and then went to the local speedway to buy cigarettes. When he returned to his residence and was apprehended by the police, he immediately began lying, claiming that he had been home all day other than his quick trip to Speedway. When he was interviewed by detectives later that evening, he continued to lie, claiming that he was only gone from the house that day for about 10 minutes, and he further told them that the only gun he owned was a shotgun that was used for trap shooting. Think about all of the actions that the defendant took that day, the planning and preparation to carry out this shooting, and the efforts he took to cover up his actions. And now he wants you to believe that he doesn't remember anything about that day? And remember, he's not claiming that he was intoxicated or that he was high. He was perfectly sober. He just wants you to believe that for some mysterious reason, he has no recollection of that day at all. That's absurd. What he's really trying to do, Your Honor, is to get credit for accepting responsibility by entering a no contest plea while still professing and hoping that you will believe that someone like him would never commit such a violent attack if he was only in his right state of mind. What a coward. If you're going to accept responsibility for something, own it. Don't try to hide behind this phony nonsense about not being able to remember when there is zero evidence that you were under the influence or suffering a mental break. What's even more surprising in the sentencing memorandum offered by the defendant is the assertion that he did not have any concerns for his child's safety when she was with Emily Bear, and that Emily consistently provided a loving and stable home for his daughter. So that means that he was willing to kill someone who had voluntarily raised his daughter from birth and only showed her love and affection. And think about what this would have meant for his daughter if his plan had actually worked. If the defendant was successful, and if things had gone perfectly that day for him, he would have gotten away with murder, and his daughter would have always been left to wonder why her grandmother, her primary caretaker and provider, was gunned down in the middle of an intersection for no apparent reason. That was the defendant's preferred outcome for that day. One of the last things that I would point out is that the factors that the defendant highlights in his sentencing memorandum, demonstrating why he should receive a more lenient sentence, actually makes him all the more dangerous. No one saw this coming. Even Emily, when she was asked shortly after the shooting whether the defendant could have been involved, stated that she did not think that he would do something like this. The fact that there were no outward signs of anger or aggression towards Emily makes the methodical and calculated actions of the defendant all the more concerning. No one thought the defendant was capable of such a violent and senseless plot to murder someone. That's borne out in all of the letters that the court received. Only he knew what he was truly capable of, and because of that, he almost got away with it. Finally, Your Honor, there is one sentiment in the defendant's letter that I actually agree with. At the conclusion of the letter, the defendant suggested to you that 20 to 30 years in prison would not be appropriate for someone like him. And I couldn't agree more. 20 to 30 years is too light for what this defendant did. When you consider all that the defendant did to carry out this attempted murder of Emily Bear, when you consider the fact that a completely innocent third party was shot and injured in broad daylight just for driving her vehicle through an intersection, and when you consider the fact that he fired so indiscriminately and so many times that one of those bullets went into the home of another completely innocent third party, 20 to 30 years doesn't seem like enough for all that the defendant did on that day. Therefore, we think a sentence in the range of 30 to 40 years is more appropriate when you consider all of the facts and circumstances and take into account that he is still being dishonest with this court with that self-serving letter he submitted, claiming to have no memory of that entire day. Thank you, Your Honor.
Thank you. Anything from probation? Mr. Booth?
Judge, you want us here at the podium?
At the podium, please.
Yes, sir.
Go ahead.
Judge, thank you. As a court, we spoke about this matter in chamber. The court acknowledged that defense did file a sentencing memorandum in this case, and it's also referenced by Mr. Knippen's speech as well. I wasn't planning on saying anything further, but I feel like a response, at least to Mr. Knippen's statements, I think they're a bit disingenuous in terms of how he's characterizing Mr. Bays' letter and all the letters and support that were provided. And part of a sentencing memorandum is defense asked the court in mitigation to look at all the sentencing factors and sentence an individual that's consistent to the circumstance with all other cases that the court has looked at and similar in nature. And I understand this is an allegation of a violent offense, but Mr. Bays did plead no contest, and part of that is, and from a defense lawyer's point of view, is there's an acceptance of responsibility for the purposes of a sentencing, but also he's still maintaining the no contest plea based upon the advice of counsel, and he intends to appeal for the purposes of some pretrial motions that we've had in this matter. So I think I don't want the court to consider that, based upon my advice, that Mr. Bays did accept responsibility for the purposes of writing a letter to the court. I think he should be given credit for that in terms of what he's done, and all the other letters and support that were provided on behalf of Mr. Bays, and ask the court to follow the sentencing, the principles and purposes of the statute in terms of sentencing, and sentence Mr. Bays consistent to what other cases that have come before the court. Also, Judge, I would note, I don't think I addressed this in my sentencing memorandum, but for the purposes of any financial sanctions, Mr. Bays has been incarcerated in this county jail since October of 2025. He's obviously had no income. I'd ask the court to consider that any financial sanctions. But other than what I put in my sentencing memorandum, I think Mr. Bays is ready to proceed to sentencing, Judge.
Mr. Bays, is there anything you'd like to say?
No, sir.
All right. The court has considered the statements made here today, the purposes and the principles of sentencing, including punishment, deterrence, and protection of the public. The court has reviewed the pre-sentence investigation and has reviewed the sentencing memorandum and letters attached that have been submitted by the defendant. Mr. Bays, I got to tell you, I've been on the bench for almost 10 years now, and I have never seen anyone that has done so much prior calculation and design, formulating a plan to go and to lie in wait and ambush someone that they know over a potential court ruling. This is new to me. I mean, you read stories of people driving across the country and shooting and killing a former family member or something. Didn't think it would ever happen in Warren County. I live in this community. I am shocked by your conduct. I'm shocked by what I perceive to be as your lack of remorse, your lack of accountability. But I don't even know what else to say. But I'm going to tell you right now that from my perspective, the overriding principle of sentencing that I'm considering is not only punishment, but I have to protect my community. So, court does find that a prison sentence is necessary to fulfill the purposes and principles of sentencing. The court is dealing with multiple offenses arising from the same incident. The court does find that counts 1, 2, and 3 merged. Counts 2 and 3 merge, the state electing to proceed on count 1. And as to counts 4, 5, and 6, counts 5 and 6 merge as they are allied offenses of similar import. Into count 4, the state electing to proceed on count 4. So on count 1, the court is going to order you to serve a minimum term sentence of 10 years, a maximum term sentence of 15 years. On count 2, the court is going to order you to serve a sentence of 10 years. That to be, strike that. Let me back up. On count 1, 10 to 15 years plus 3 years on the gun spec. That to be served by law consecutive to the 10 years. On count 4, the court is going to order you to serve 10 years in prison, plus 3 years on that gun spec, those both to be served consecutive to each other and consecutive to count 1. On count 7, the discharge offense, the court is going to order you to serve 3 years in prison, plus the 3-year gun spec, those to be served consecutive to each other and consecutive to count 1 and 4. And on count 8, the court is going to order you to serve 3 years in prison and 3 years on the gun spec, those to be served concurrent with each other and concurrent with count 1, 4, and 7. You have 246 days jail time credit. I'm ordering restitution to Emily Bear in the sum of $200, to Jeff Piper in the sum of $1,000, in the sum of $1,300 to Rebecca Noble, I apologize. Other than those restitution orders, the court finds that you're indigent for the purposes of other fines, costs, or financial sanctions. You're also subject to a mandatory period of post-release control, which means that when you are released from prison, the Adult Parole Authority will supervise you for not less than 2 years nor more than 5 years. If you violate that supervision, the Adult Parole Authority can return you to prison for up to 1/2 of the court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. It is possible, these are mandatory sentences, so I'm not going to get into the good time. You have been convicted of or pleaded guilty to a qualifying violent offender offense as defined in the Ohio Revised Code. You are not, have you seen this?
Yeah, no, I have not.
You have not? Do you want me to go over this with you on the record?
No, thank you.
You want to waive it? I'm going to waive reading this. I'm going to have the probation officer sit down with him and have him sign it. Do you want me to go on the record with it? Consecutive sentences are necessary to punish this defendant and to protect the public from future crime. It is not disproportionate to the conduct or danger posed by the defendant. And these offenses were part of a course of conduct, and the harm caused is so great or unusual that a single prison term would not adequately reflect the seriousness of the conduct.
Thank you, Your Honor.
Thank you. Anything else?
No, Your Honor.
Mr. Booten.
Judge, only that for the court to note the defense's objection with respect to the court sentence today for the purpose of the appellate record.
To my sentence?
Yes, sir.
I would anticipate he was going to object and file an appeal.
Yes, sir.
You can have a seat at council table. Anything else?
No, Your Honor.
All right, thank you. Court's adjourned.
All rise.